Everyone. Good afternoon, colleagues. My name is Siobhan Mullally. I'm the director of the Irish Centre for Human Rights here at the University of Galway, and we're delighted to welcome you all to this webinar launching our new master's programme in Transitional Justice, Human Rights and Conflict. We're really delighted to have this opportunity to welcome very distinguished speakers here. Professor Stéphane Parmentier joining us from Leuven, and Judge Oscar Para-Vera, who hopefully will be joining us very shortly, from the Special Jurisdiction for Peace in Colombia. And this is quite a special occasion for us. Our colleague, Dr. Anita Ferrara, has led the development of the new master's programme, which builds on the success of our teaching and research in the area of transitional justice for over a decade now. Transitional justice has been a specialised elective module across all of our master's programmes. It has been a very popular master's subject, with several students not only pursuing the subject area, but also continuing on to undertake master's dissertations and doctoral research in the field. And it's thanks to Anita's expertise and inspirational teaching that we have seen such success in the area. And over the last year, several doctoral researchers completing their PhDs, graduating and moving on to new programs of work in the field of transitional justice. This is an area that is rapidly evolving both in academic research, but also in practice, as post-conflict societies and transitional societies look for new ways to build peace, to reflect on the legacies of the past, to seek justice for the atrocities that occurred during conflict, and to look at new ways of building peace and reconciliation between communities. It's a subject area, of course, that is very relevant to us here on the island of Ireland, where we continue to grapple with the legacy of conflict and serious human rights violations, violations of international humanitarian law, and questions about how to ensure accountability for the past while moving forward and building new settlements for peace. So with that background, and with our students and researchers joining us from different parts of the world and bringing their experience and expertise, we are taking the opportunity to launch a new specialized program which brings together both the study of transitional justice, but also international human rights law, international humanitarian law, international criminal law, gender and human rights, Islam and human rights, business and human rights, a whole range of elective subjects that will be available to those who study in this field. It builds and will complement other programs in peace operations and humanitarian law. And we know that many of our graduates who move on to practice in the field will need the skills that they will acquire through the study of transitional justice to pursue careers in the field, but also to continue to have an impact in building peace and promoting human rights protection at this critical time globally, where we see very serious threats to our multilateral international system for rights protection and for the pursuit of international justice. So with that, I'm going to hand you over to the real expert in the field, to Dr. Anita Ferrara, my colleague who has led the development of transitional justice with a particular interest in Latin America through her studies, her research and her practice in Chile, more recently also in Colombia, and also looking in collaboration with our researchers to post-conflict jurisdictions in the African region, particularly in West Africa. So over to you, Dr. Anita Ferrara, and I leave you to introduce the next stage. Thank you.
Thanks a lot, Siobhan, for the kind introduction, and thanks a lot, everyone, for joining the launch today. And I'm very happy to see that Judge Oscar Parra has managed to join us as well. So very timely, Siobhan, you just finished, and Oscar entered into the call. So very nice to have you here. I'm very honored to have both Stefan Parmentier and Oscar Parra to launch and to join us in this launch, because they are both well-renowned scholar and academics, but also because they have given, and I'll start with Stefan and in a second with Oscar, they have given the major contributions to the field of transitional justice, and that's why I'm very happy to have you both here. Stefan hugely contributing to the field for many years now, and Oscar Parra contributing to the development of one of the most innovative transitional justice mechanisms being implemented worldwide, on which, as we were saying, most of the world attention is currently focused on, for many reasons that Oscar is going to talk about in a minute. I'll just add to what Siobhan was saying, a few words about the LLM in transitional justice, human rights and conflict. I think it's a very nice addition to the center, which is already very well renowned for its role in the research of international human rights law, international criminal justice, international humanitarian law, and many other subjects subjects related to international human rights protection. But I think that this LLM complements a lot of already existing subjects, and it adds a more holistic overview of the way societies address massive human rights violations, adding a restorative justice component, and so a subject that is focused not only on non-judicial subjects, but also and mechanisms and approaches, but also specifically restorative justice mechanisms and approaches, both national but also local. And the LLM aims to focus a lot on other mechanisms. I don't like the word mechanisms with which transitional justice is defined. I prefer to use themes, specific country case studies. I'm more of a fan, not of the standardized mechanism, but of the approaches and methods that countries, societies, and victims groups implement, because we always forget that it's mainly a victims focused and centered field. That was the beginning of it, and that it has to remain to be a victim focused. And for that reasons, it also works a lot with perpetrators, and not to include the perpetrators into the conversation. That's why it's so much the interest of the JEP today and the world on the JEP. If I have to highlight a few of the strengths that I would say hopefully will distinguish this LLM from other program of studies, it's global outlook. So it really intends to look at in-depth case studies of what's happening around the world. It does not want to repeat standardized approaches to transitional justice, so it will include a lot of the critical literature that we've been developing in the last 20 years, and hopefully to integrate it into the more traditional mechanisms of transitional justice. This comes from the addition of, as Siobhan was saying, a few brilliant PhD students that have conducted brilliant research in Liberia, in Colombia, in Central American countries, currently in Palestine, and hopefully it will expand even more. There is an increasing interest. It's one of the most daunting pressing issues of our time. And the issue of how to negotiate peace and justice is not been resolved. It's still very much a complex issue. We easily say that, peace and justice can happen simultaneously, but the reality of what's happening in many countries, it does tell us another story, which is very different from the romanticization of the possibilities of having all the mechanisms, all the approaches together in countries where actually are destroyed by conflicts, the social texture is destroyed by massive human rights violations. So I would say this is the distinguishing aspect of this LLM compared to other LLM studies. It's a global South focused LLM. It introduces a critical perspective to transitional justice, and it actually aims to focus a lot on the empirical studies of specific country case studies, which is one of my one of my research methods on which I'm mostly focused, which is the country case study, going in depth into a country and studying knowing exactly what that society, what that particular groups of victims are doing in order to face such daunting atrocities. On that, I will actually, I'm very happy to give the word to Professor Stefan Parmenter, who I'm introducing very briefly. Stefan has a very long biography, so I apologize for not mentioning many of the things that you've done. Professor Stefan Parmenter's contribution to transitional justice are extensive and multifaceted, reflecting his deep commitment to advancing human rights. As a renowned scholar and educator, Parmenter's research and teaching at the University of Louvain has significantly influenced the field of transitional justice, particularly in the area of sociology of crime, law and human rights. He is the Secretary General of the International Society for Criminology, Paris, since 2010, an advisory board member of the International Center for Transitional Justice, New York and Brussels since 2014, and he was on an advisory board on the Oxford Center for Criminology between 2010 and 2023. In November 2017, he received the award Third Way from the Serbian Society of Victimology for his research in a non-conflict and comprehensive approach to dealing with war and war crimes. Stefan Parmenter is the founding general editor of the first international book series on transitional justice published by Intersensia and founding editor of the International Journal of Restorative Justice. In 2016, he established the Fund on Transitional Justice at KU Louvain, and in 2020 he co-founded the International Academic Network on Memory, Truth, Justice with colleagues from Argentina, Belgium and Spain. Through his leadership in various academic and advisory capacities, he continues to shape discourse and practice in transitional justice, fostering dialogue, collaboration and transformative change on both local and international levels. And with that, I'm very happy to hand over the word to Stefan, after which I will introduce the other distinguished panelist, Oscar. Thank you.
Thank you so much, Anita and Siobhan and colleagues of the Irish Centre. Can you hear me well? Yes? Okay, thank you. Well, it's a great pleasure and a great privilege, I would say, to be part of this launching event. And thank you so much for the kind words and for inviting me to be with you today. Let me first of all congratulate you. How could I not congratulate you with this fantastic milestone, I would say. You briefly talked about the importance of this new LLM, and indeed, I think it is important. Not only is it interesting in intellectual terms, if you look at the coursework that is being offered, and also the speakers and the teachers that will be involved, that's quite impressive in itself. But it's very much needed because our world is increasingly, let's say, characterized by polarization, by conflict, by dissensus, rather than the consensus or the conflict resolution that we've been living in the past couple of decades after the fall of the Wall of Berlin. So for that reason, it's very much needed. And what we need in the world today is also more people who are better trained in understanding complexities of conflict, of violations, and hopefully with the idea that they will be able to contribute to overcoming that conflict and those violations. So for that reason, or for those reasons, I would say this is a really important endeavor. I've been trying to reflect a little bit on the title of your program, first of all, because it actually captures really well several aspects of what we are talking about and what you hope to develop as well. So first of all, transitional justice, that is the key term, the key notion, and I will go into some further thoughts about that in a second. Secondly, the human rights aspect. I think the two are very closely linked. It's very hard to separate them as if they would be distinguishing worlds or distinct worlds. But human rights is large, and in technical legal terms, of course, we talk about human rights under the human rights law system, but also the criminal law system, and also the humanitarian law system, not even to speak about general international law. So various bodies of law come together here in this particular notion. And then conflict. Wow, well, that's a big notion as well. I think it makes sense to talk about conflict and to study conflict from the perspective of transitional justice. But of course, conflict is a very fundamental characteristic of basically any society. The kinds of conflict, of course, that are being highlighted here or the types of conflicts of a violent nature. And the violence in the broadest sense of the word, physical violence, psychological violence, material violence, institutional violence. So I think to talk and to go deep into those notions is very much needed for any graduate who would like to improve his or her skills and knowledge in this area. The very fact that you call it an LLM, Master of Laws, Magister Legum, for me does not exclude, on the contrary, I would say, the interdisciplinary focus. And having heard you and knowing your work in Galway and beyond, I'm very much convinced that you will take this occasion, that you will seize it in order to expand that, at least that multidisciplinary approach, and also engage with interdisciplinarity. It's a word that is very often used, and it's also a word and a notion that is often being paid lip service to. But the reality, of course, is not so easy. It's not easy to do interdisciplinary research and to understand other disciplines, first of all, and to let them talk to one another. That's quite a challenge, and it requires an enormous openness of mind, a willingness to engage, and of course also makes life a bit more difficult because it forces us to go outside of our comfort zones. At the same time, more exciting, I would say. And the real challenges and the real innovations, according to me, lie in that engagement with different disciplines and different languages of different disciplines. So this is, let's say, first of all, a very, very general set of remarks on the title and of the new LLM degree. And of course, wishing you all the success possible. Now, please allow me to go a little bit into that notion of transitional justice, which seems so straightforward as it's often used in all kinds of titles of book series and journals and programs and what have you. But I think it's good to reflect even on that fundamental notion as well. If you look at many websites, of course, they will always talk about the mechanisms that Anita was referring to. Some call it instruments. Sometimes the notion of tools is being used as well. And that leads us very quickly into that area of toolboxes and the toolbox idea, which is, of course, a little bit tricky, one could say. But in those mechanisms, and so normally 4 of them are identified very clearly. One being criminal prosecutions, and most likely Oscar will talk about that. Then, of course, truth commissions, it said, and possibly some kinds of other truth-seeking procedures. That is usually the second one. The third one is often victim reparations in their various dimensions. And the fourth one would then refer to, let's say, guarantees of non-repetition. It's often said in legal terms. Basically, it's about institutional reforms. It's about training and trying to prevent similar violations to take place in the future. So these 4 mechanisms are often regarded as the, let's say, fundamental to transitional justice. I would like to suggest that definitely they are important, but that we actually take a step backward and try to think why they were developed and in which way they could serve, and actually what kind of intricacies are brought by looking a bit beyond these specific notions. And in order to do that, I would like to take 2 steps, if you allow me, and the time does. First of all is to briefly reflect on the origins of the notions of transitional justice and of the so-called pillars or mechanisms. And for me, these notions, these origins lie in the whole international combat against impunity. I think it's not a coincidence that the basic principles to combat impunity were developed alongside many ideas of transitional justice. In the United Nations and outside of the United Nations, impunity and fighting impunity is an old debate, obviously, but in the late 1980s and early 1990s, it really became a very important element of international relations and international law. And many of the reports that had been issued in those days are basically talking about three main elements, three main aspects. First, the right to know for people about the violations committed. Secondly, the right to justice, which tends to mean the right to see the persons responsible being brought to justice, in this case, mostly criminal justice again. And thirdly, the right to reparation. Now, that right to reparation, obviously, for victims and for those affected, has developed further through all kinds of soft law and hard law mechanisms in the ensuing years. But I would like to suggest that we start there, or let's say we focus our attention on those initial years of the fight against impunity. And impunity of what? Impunity of violations of human rights and humanitarian law. That was the technical definition at the time. Of course, today, when we speak about transitional justice, we mean many more things. We mean crimes, international crimes, and that's the more legal definition in the criminal law area, which has gained a lot of ground and momentum in the field of, well, genocide, for example, or crimes against humanity. All kinds of legal instruments have been developed, are being developed in this area. So the legal and the non-legal field will obviously have to work very closely together in order to understand these crimes and these violations. However, in the field of justice and transitional justice, it seems to me that not only that relationship between dictatorship and democracy, or war and peace, but of course also long-term legacies of human rights abuses are being integrated these days. And you can almost see it as the first, second, and third generation of ideas around transitional justice, if you wish. So today, actually, it means a lot. It means it's a very wide field, a very vast domain. It's no longer only the dictatorships of Latin America that have fallen and are replaced by more or less democratic regimes. That in itself is a whole analysis and needs a whole analysis. What is democracy today and the rule of law, if you see it being encroached upon in various parts of the world? Also, the issue of war and peace is more problematic than is often thought. War can take many shapes, and peace, let's say, or the silencing of the arms can also take many shapes. We often make that distinction in the field between negative peace and positive peace, and that in itself is already worthy of further analysis. And then the large-scale abuses. Well, many so-called mature democracies have their own issues. Think of Canada, think of Australia with the residential schools, think of so many other countries that are facing long-standing discrimination practices against a particular minority in the country, and so on and so forth. So basically what it means today to talk about transitional justice and to study the field is actually to engage the whole world. I don't think there is any country that could legitimately argue that there is nothing in its own history or its own present that would not justify a particular focus on transitional justice. That makes it challenging, at the same time also extremely exciting. We've also always been arguing in our work that transitional justice actually is like a kind of a mirror that is being posed in front of any given society in order to look into the mirror and to look into one's own past and one's own reality. So these are a couple of reflections on the TJ area. Let me then finalize maybe the talk or the short intervention by talking a little bit about what I consider some current issues and some current challenges for the field. And I would be really interested to see in which way you think you can pick that up in this program, which again has a focus on law, obviously, and legal studies to start with, but is actually designed as a much broader program that would also engage with other disciplines. First of all, the various notions of justice. In fact, to say that something belongs to the field of transitional justice is a bit clinical. It doesn't say a lot about the type of justice that we're talking about, the type of justice that could be discussed, the type of justice that could be developed. It's often assumed that justice means the justice system, the institutions, the procedures, the actors of justice that are in criminal justice and in civil justice, sometimes even in administrative justice or constitutional justice, even working hard to continue on in an individual basis and talk about individual conflict resolution systems, let's say, in particular cases. They often have the connotation of being retributive, adding new, let's say, harm to the harm that has been done by the persons who have been charged, indicted, and then possibly convicted. That retributive justice has dominated for a long time the field of transitional justice, I would like to argue. It has to do with the influence of lawyers in the field and the influence of political scientists in the field, that's for sure. But of course, gradually and rapidly, in a certain way, other notions of justice are coming up. Oscar will undoubtedly talk about the restorative justice element in the JEP in Colombia, so I will not dwell too long upon that, but it is worth to consider to which extent these challenges of truth and reparation and so on, and accountability can also be served through specific mechanisms that are relying on the principles of restoration rather than on retribution. And this is not to say that both are necessarily exclusive, mutually exclusive. They could also go hand in hand. They could also reinforce one another. They could also be complementary. But these thoughts, these ideas, these initiatives are just at the beginning, I would say, of this international development. Related to that, to the restorative part, or in, let's say, paradigm, if you wish, there is also that necessity, it seems to me, to think, particularly in some countries, of traditional forms of justice, which often are called restorative in their own right, which are historical often in terms of origins and operational modes, and which may contribute in many African, Latin American countries, and I'm sure in many other parts of the world. Those traditional circles, traditional forms of conflict resolution do play a role, often in civil conflicts rather than criminal law conflicts, but nevertheless, they can maybe also generate some interesting ideas about how to sit together, let the weapons be silent, and then try to restore the harmony in the particular circle or in the particular community. So to learn from traditional justice in the field of transitional justice seems quite relevant as well. And of course, the other notion that is so much used today in the Anglo-Saxon world, but much beyond that, is transformative justice. The idea being that, well, it's not enough to look back to the past and try to amend it to a certain extent, but to fundamentally transform society through the distribution of land, for example, or through reforms of political institutions, or all kinds of educational systems even. So all kinds of initiatives that go along the lines of building a new future. And that idea of peace building and transformative justice actually often go hand in hand. So this is one particular challenge in terms of models of justice that could be raised and could be figuring in the program. Then a couple of other things. Anita, you were involved in a book project on memory politics, and particularly on localizing memory in the field of transitional justice. So there's a lot to be done in that area as well. In fact, some argue that TJ, as we often call it, TJ today, is not limited to these 4 pillars or these 4 mechanisms, but that memory construction, memory building is coming up as a full-fledged 5th pillar. And it definitely warrants further attention, I would say. particularly because memory can also be one-sided. Memory can also generate new conflict. Memory is not the kind of panacea solution that would solve everything and then construct a collective consciousness, to use the words of Emile Durkheim, that famous sociologist at the time. But memory can also generate new forms of polarization and conflict. So let's not underestimate that, and study at the same time how things are being developed in that particular field. Another element, for example, that comes up very quickly and very prominently these days is everything related to mental health. Mental health, and then in one breath, and psychosocial support. This has been around, of course, in court procedures for a while, in truth commission procedures for a while. But this new idea of MHPSS is much larger. It actually assumes that a society and the people living in a society all need a certain level of mental health, and that violent conflict of the nature that we talked about and violations of human rights that are so incisive to affect everyone, including the social fabric of society, have a tremendous and detrimental effect on people's mental health. So to restore that mental health, to create mental health solutions from the very start, to prevent mental health disturbances, I think is another really interesting part. There is actually a link with law and legal studies, because the right to mental health and the right to be served from the perspective of mental health is also an existing right. And then finally, maybe I would like to highlight the importance of empirical work. Basically, coming back to some of the points that Anita was referring to in the beginning, because often transitional justice, I would like to suggest, and conflict studies in general, tend to be fairly focused on top-down approaches. Top-down approaches by elites, governmental elites, political elites, let's say, well, business elites, cultural elites, even many NGOs belong to the elite sphere. But where do they draw their information from? Often from the affected populations. And so the idea here is, of course, that the deep analysis and the skill breeding of any future professional in the field will have to take into account those ideas from below. And the from below can be taken into account in different ways, by literally doing interviews, by observing, by collecting quantitative data, by a variety of means, but the basic idea always being the same, that you want to capture voices from the field and want to be able to enlarge the understanding of the complexities of justice and peace, not only by talking through reports and governmental recommendations and legal regulations, but of course also making sure that that dialogue between the top-down and the bottom-up approach can take place. So also in our work, we have tried always to integrate that into our specific work, whether it was through interviews with people involved in the South African Commission, for example, Truth Commission, or more recently in Colombia, with persons going through the HEP process, or in other parts of the world, in Bosnia and Serbia, through a quantitative survey. But I think it's really, really important. And that adds to the interdisciplinarity at the same time as it adds to the comprehension of this very exciting and also complex field. So thank you for that. And I hope we can engage in some further thoughts. Very happy to be at your disposal. Thank you again, and congratulations with this wonderful new program.
Thanks a lot, Stefan, and thanks for giving us such a broad overview of the field, which you made it wonderfully like to highlight of the most important developments and challenges of the field. And I'm very happy, I mean, as I knew your scholarship, so I know that we are very much aligned with certain ways where we would like to see transitional justice is going. And so I hope that I'll be able to certainly add that interdisciplinarity, multidisciplinarity, which it's something that's really dear to my heart, although it's difficult and it takes much more time, and but I think it pays and rewards in the longer term, and to open up the field to other approaches, which is still, that's the point. The challenge is to be fully legal mechanisms, but that are not only criminal justice and that are all not fully established in the retributive justice framework, but actually to open up to many more frameworks of justice. So hopefully we will be able to establish as an international hub of restorative, reparative, historical justice, and many more forms of justice that maybe will come up in the next few years, which we still don't know. We wouldn't know. We would be speaking about so many forms of justice probably 20 years, 30 years ago, while we are doing it today. So I'm optimistic. I think that that's the way forward. But we'll talk in a few years' time about this. Let's see if I've managed to do that. I'll hand over thanks a lot, Stefan, really, and I'll hand over the word to Oscar, Oscar Parravera. First of all, thanks a lot for joining us today. I know that you are one of the busiest person on earth at the moment in the field of transitional justice. So the fact that you took the time to do this, I'm very, very deeply honored. I've had the honor of meeting Oscar Parra last year in Colombia, and we're going to meet soon again because we've recently collaborated on a book project that works on transitional justice archives. And so the way transitional justice mechanisms build their archives and what's been done with the documents left by transitional justice mechanisms that are going to have deep impact on the societies over the medium and longer term after the mechanisms finish this work. And Oscar is doing brilliant work on this point. So this is a forthcoming book published with Routledge, which is about to be published in May. We're going to present it in Colombia, and I'll be very happy to join Oscar again. For now, I introduce Oscar and then I leave the word to him. He's a magistrate for Colombia Special Jurisdiction for Peace, which is the most important retributive justice mechanism established in Colombia. Actually, it's a restorative retributive justice mechanism established in Colombia. He's Senior Associate Research, the Program for Studies on Human Rights in Context of Ghent University. He holds a MC in Criminology and Criminal Justice from the University of Oxford, and is a lecturer at the National University of Colombia. He has worked as Senior Legal Officer at the Inter-American Court of Human Rights, Fellow and Consultant of the Inter-American Commission on Human Rights. He's been a guest expert of the Working Group on Enforced or Involuntary Disappearances. He has frequently assisted and advised the Human Rights Council and the Office of the High Commissioner for Human Rights. And with that, I know it's a longer biography, Oscar, forgive me. I have actually cut it down as a matter of time to give you more time to speak. And thank the word to you talking about the JEP and the extraordinary work that you're doing in Colombia. Thank you.
Thank you very much, Anita, for this presentation. Thank you, Anita. Thank you, Siobhan, and thank you, Stefan, for the previous presentation. It's an honor for me to be part of the launch of this new LLM program, and it is an honor to be invited by the Irish Centre for Human Rights. And I would like to present some ideas using a PowerPoint presentation in order to be clear in some of the aspects that I would like to highlight about the work of the Special Jurisdiction for Peace. This is only a brief presentation of some trends to the field of transitional justice that the experience of the special jurisdiction presents as a new development, as a new trends, as a new issues to think, in particular for this kind of new programs like this LLM. And let me begin to this interesting idea about the relationship with the ICC. In 2021, the prosecutor Karim Khan closed the preliminary examination by the prosecutor of the Office of the Prosecutor of the ICC after 17 years of the preliminary examination. This is so important to understand the scope of the model because the ICC backs the Colombian's model, obviously opening a door for the possibility of new analysis, new evaluations. But the idea is that a model, including restorative justice, as an avenue for the sanctioning of crimes against humanity or even the most war crimes, it's a possibility in the context of transitional justice. This is a new idea in the field. There are some criticisms, there are some developments in the context of positive complementarity. The Colombian case is one of the more important examples now of this idea of positive complementarity. And I would like to present during this short presentation some ideas of what the ICC, what the prosecutor of the ICC found to close the preliminary examination. The first one is the kind of composition of the special jurisdiction for peace. We are 38 magistrates. The majority of my colleagues are women. 4 of my colleagues came from indigenous populations. And this is so important in the new approach that we have been constructing during the last years. 5 of my colleagues are Afro-Colombians, and we were selected in a public and transparent process. And I will present some ideas considering my intervention in some of the developments of the new avenues of the special jurisdiction, considering the macro cases and the restorative justice activities. And we're talking about a country with more than 6 decades of non-international armed conflict. And obviously, I have to say that now we have a different kind of armed conflict, different to the kind of armed conflict analyzed in the peace agreement. We have new scales of violence now in Colombia, but the most important part of the work with the guerrilla of the FARC were closed with this peace agreement in 2016. And the very big questions behind the peace accords were associated to these particular topics. The first one is how to combine the effort to find justice for victims with the effort of achieving political settlement for an armed conflict. And this is so important because during the peace agreements, the state recognizes the kind of political actor that the guerrilla of the FARC was in the past, but also a political actor committing international crimes. And it occurs in a very complex country like Colombia. The second idea is the impossibility of amnesties regarding international crimes. There is a lot of debates on that. You will see this during the LLM program. Obviously, there are positions, scholars like Mark Freeman saying that, well, there is a possibility, the new possibility for amnesties, and some scholars saying that there is no necessary we can see different kind of approaches, but for the Colombian context, considering the the role of the Inter-American Court of Human Rights and the ICC, it is impossible to grant amnesties regarding international crimes. And because of that, the new avenue constructed in the context of the peace accords was the creation of the special jurisdiction for peace as a creation emerging from the peace deal. It's not a kind of, it's not the similar to the ordinary justice in the context of Colombia. And the main objective is the legal closure for the armed conflict. And only to take into account, but this is a lot of information, but we are judging approximately 10,000 members of the FARC, approximately 4,000 members of the public security forces, and some civilians who participated in the Colombian armed conflict who voluntarily presented submissions to the jurisdiction. And we are dealing with more than approximately 400,000 victims participating in the procedures. And because of that, we have been using the concept of the approach of macro criminality, macro cases, mega cases, using putting in one procedural avenue a lot of thousands of crimes. And because of that, we construct a very big 11 macro cases. And let me explain a little bit about this new approach and the importance for the field of transitional justice. The idea here is a new approach in prosecuting macro criminality, overcoming the case-by-case, individual and isolated approach, and proposing the prosecution of systemic crimes using macro-criminal patterns and analyzing criminal plans. This is so important because previously the ordinary system analyzed the cases in an isolated approach. And because of that, they didn't have the opportunity to connect the cases. And because of that, we have to use a different kind of method of investigation. We use strategies based on prioritization and selection of facts and people. And this is a very long story, but this is important considering the method. And on the other hand, we focus our work in unveiling the main and highest criminal responsibilities. We focus our work in the most responsible of the crimes. This is complex, and this open a very complex debate because it is not possible for us the prosecution for every crime and every perpetrator. And because of that, the idea is, let me show an example considering a macro case that I will explain later. The ordinary system prosecute a lot of thousands of soldiers in an specific macro case related to extrajudicial executions, but not any general, any colonel in the highest rank of the chain of command. And because of that, our main objective is the most responsible. And the other idea is to construct a restorative procedure. We open 11 macro cases, but let me explain with a special focus in 3 of the cases to open the idea, some ideas about new developments of the special jurisdiction for the field. Considering a specific macro case on false positives killings, these extrajudicial executions during the war. We analyzed at least more than 6,400 extrajudicial killings and around more than 4,000 members of the army involved. And we are dealing with more of 4,000 victims participating in the proceedings. This is a new challenge because we are not talking about one victim, 10 victims, 100 victims. We are talking about more than 4,000. In this case, we have another macro cases with a lot of more victims participating. We use until now more than 700 cross-examinations, and we organize hearings of acknowledgement of responsibility, and we called more than 20 former generals, for instance, for to have cross-examination. And we found that these extrajudicial executions were committed as a result of a de facto policy, not a legal policy, but a de facto policy behind the several regulations in the context of the army. And in that policy established the body of the enemy killed as the main indicator of the success of the military effort. And because of that, a lot of pressures over soldiers, over officials in the low chain of chain of command, construct an environment for the organization, execution, and an impunity of the crimes. And some ideas that are important to take into account with these indictments. First, the use of international criminal law to analyze the cases. This is so important because the ICC found that we use all the jurisprudence of the ICC, all the standards of evidence of the ICC, and in some way we did the work maybe they have to do in the daily basis of the ICC. We analyze the most responsible of these crimes. We determine the patterns of macrocriminality, and we organize with the people who acknowledge responsibility. We organize public hearings. In my view, and I would like to focus in the final part of my presentation here, this kind of public hearings has been one of the most important success of the special jurisdiction during these last 8 years. Why? Because, for instance, in the case of the extrajudicial killings, a lot of people said in Colombia that maybe this phenomenon have never occurred, or maybe they are only bad apples. They are only criminals, isolated criminals inside the army, but not a policy, not a kind of a systemic crime involving the highest responsibilities. And in this first hearing, this is a picture of this hearing, we can see the magistrates of the special jurisdiction at the center, victims at the left, and the most responsible, even a general, in the right hand of the picture. And we can see here a general, colonels, and military personnel face to face, with a lot of emotions during the hearings, with a lot of expressions who transform the narrative in Colombia about these issues, because we did a judgment of maybe 300 or 400 pages, but not on in Colombia, people remember only the hearing, because the hearing communicate in a different way the kind of justice that we have been developing. And one important idea here is that the voice of the victims was the path to acknowledgement of responsibility. A lot of the most responsible say that we never had heard the voice of the victims, and it transforms them in order to present their apologies in public. For instance, one of the generals said, "I present my feelings of forgiveness for the great pain caused by the execrable acts committed, which lead to the deaths of innocent people who were marked as combatants, leaving deep desolation among their loved ones." This is important because a lot of people say that maybe they were killed because they were members of the guerrilla movements, or maybe they were doing bad things. And a lot of victims and a lot of families need to restore the good name, the goodwill of their familiar, of their next of kin. And this is so important during these hearings. And another major general acknowledged responsibility in another hearing. And this is so important because a lot of people cannot believe that generals participating in this kind of extrajudicial executions. Until now, we are talking about approximately 200 of the most responsible people at the army and in the guerrilla of the FARC acknowledge responsibility. Talking about the criminal patterns regarding the planning, executing, and cover-up of the crimes. And this is so important. Some perpetrators have confessed their participation in serious crimes never investigated by the Colombian justice. And this is a success against the denial in public discussions and the denial of the kind of systematicity and widespread of the crimes. And finally, to close my intervention, let me show few examples about the cases relating the FARC, the guerrilla of the FARC. One case is related to the war crime of hostage taking and crimes against humanity of severe deprivations of personal liberty and others by former FARC rebel group. We analyze in this macro case, the case number 1, approximately 20 years of kidnappings and approximately more than 20,000 of kidnappings. And this is the hearing for the first time in the field, for the first time in a comparative way, guerrilla leaders acknowledge full responsibility for war crimes and crimes against humanity. And this is so important because at the very beginning of the procedure, they explain with some hesitation that they develop some ideas of justification of the crimes. This is a war, this is a necessity, this is cruel, but that is the war. But at the very end, and considering the dialogues with the victims, they acknowledge the seriousness of the conduct committed, refrain from justifying them, and recognize the damage caused. And this is so important, the discussion about the harm. The public hearings presents to the society the kind of harms, individual harms, family harms, and collective harms that we have we found in these macro cases. And finally, we have a more recent macro case regarding recruitment and use of girls and boys in the armed conflict, with several developments on sexual violence, gender-based violence, including reproductive violence for the first time in the comparative approach, and violence due to prejudice against LGTB victims. And this is another contribution of the special jurisdiction. And to close this intervention, I would like to say that we construct a dialogic procedure, beginning with a dialogue with the victims and continuing with the determination of a lot of harms, and with a new dialogue with the perpetrators, considering questions like when was the first time of the involvement of this specific individual with the politic violence, to understand beyond the specific crime what happened behind this particular individual. And in that context, we put discussions between victims and perpetrators, considering the discussion about collective harms. And a very few notes for the final presentation about the importance of our developments regarding intercultural dialogue and the dialogue with indigenous peoples' jurisdictions. And I would like to finish the presentation with these words of the Truth Commissions. Let me show an example of the development of this approach at the Colombian in the Colombian case. This is part of the final report of the Truth Commission, saying that the nature is also a victim. And this is the idea. Let me put the words of the Truth Commission. Birds of life that turn into birds of death when they sing in a strange way or suddenly stop singing. Blood moons, rambunctious bees, dogs barking at the wrong time. Things that can also be read as warnings, as symptoms of a rarefied ecosystem. The question then arises, say the Truth Commission, is nature's pain a form of truth? And the response of the Truth Commission is that yes, if we accept that forests and mangroves have a feeling that we have disregarded. And because of that, we have tried to overcome an interpretation from an anthropocentrical approach to promote an ecocentric approach, both the Truth Commission and the Special Jurisdiction for Peace. And because of that, we have found, for instance, a specific river as a victim, considering the impact of the phenomenon of the forced disappearances in specific rural areas, to use the river to put the bodies of the disappeared, and the impact in the communities, in the dialogue, in the daily basis of convivence with the river. Considering these general ideas, I think that I can say that the Special Jurisdiction for Peace is trying to put some new ideas for the field of transitional justice, new debates, new horizons for research, and I hope that this new LLM has an opportunity to share these new developments and to put these experiences in a comparative approach. Thank you.
Oscar, thanks a lot for this thorough explanation of what you really managed to condense one of the most complex transitional justice system ever invented in this 20 minutes. You have highlighted so many topics that we hope here from the Center to continue studying the Colombian process for the years to come and to collaborate as much as we can with you in the field, and also because you talked a lot about what the extraordinary efforts the JEP is doing, and to me, studying Truth Commissions for many years, acknowledgement that's happening in the way it's happening in Colombia. I think it's quite revolutionary in terms of intending justice, and the same concept, you're transforming also what we intend as restorative justice as well, because you're actually putting into practice, into place, something that is actually very difficult to manage. For someone like me that I engaged with Colombia for the first time 20 years ago in 2004, which was one of the worst time of violations committed in Colombia while I was working with Roberto Garreton, that you know very well, and to see what's happening today and what was Colombia that 20 years ago when I started working human rights, it's actually, I think, a great thing to see. So I thank you, and on behalf of the international community as well, for what you're doing, because I know that you are doing an extraordinary work, which we will all study for the years to come, because we hope that this is being transformative. I think that Colombia is transforming the field as South Africa transformed the field many years ago. So it's a watershed in the field again, and you're really doing great things, and I really mean it. And I'm really looking forward to meeting you again next in Colombia to discuss about all of these issues next month, and to to launch our book as well. So thanks a lot, and thanks a lot for taking all the time to give us so much explanation. I have one PhD student who's probably in the chat now. Actually, I see his hands on, so I think he would like to ask you something because he's actually exploring the relationship between the International Criminal Court and the JEP. And so it's actually one of his central topics that's going to develop in the further few years. So I'm really thanking you both for everything that you've done for us today and for contributing so much to discussions on the topics of transitional justice. I'm handing over because I'm conscious that we don't have so much time left, but I would like to give the chance to some of the attendees to have any questions. You can either write your question in the chat or you can raise your hand and Connor will open the video and mic for you. Thanks a lot. I think I see a son that would like to have a question.
Thank you so much, Anita, for organizing this and to the center. And it's a pleasure to meet Judge Oscar and Dr. Stefan here online. It has been a very rich conversation. To be quick, I have a question to Judge Oscar about positive complementarity with regards to JEP and the ICC. This is, I think, an exceptional case, an exceptional interaction. It's not a very regular activity that we have witnessed on the side of the ICC. So I would like to hear more. What do you think about the nature of this positive complementarity of the ICC? Do you think that the ICC is supporting the process that JEP is operating? Or do you think the ICC is mostly trying to take notes to see how it can reform or incorporate further of the JEP practices for potentially other cases that the ICC is dealing with? Thank you.
Thank you, Hassan, for this important question. I don't know if we have a round of questions or I take a...
We can go ahead, like we'll take it individually.
Okay.
I prefer it because we are in the chat, otherwise I will miss someone. So we can respond immediately after the question. Thank you.
Very briefly, this is a very complex topic and a very interesting issue for research. In my view, we have to take into account something like we can call it a long approach, because previous to the peace agreement, the ICC prosecutor then, Fatou Bensouda, had some hesitations, has some doubts about the model. And because of that, the Constitutional Court of Colombia requested an intervention of Fatou Bensouda at that moment. And she said that we have some doubts about the design of the responsibility model, particularly the superior responsibility. But at that moment, the ICC intervenes at the discussions at the La Habana. In some way, I have to say that this is a new develop of the negotiations of peace accords considering the international standards. During the past, there are a lot of more politicians doing the discussions, and now we have to take into account the consequences before the ICC and the Inter-American system. And at that moment, Fatou Bensouda presented their concern before the Constitutional Court and present their concerns before the government to take into account in La Habana. And because of that, they include some responses during the lines of the peace accord. After the implementation of the special jurisdiction, the ICC began a special follow-up, saying that we have here to support you, considering that you have a lot of contestation in the local dimension, because some part of the country is against the peace agreement, and the previous government was part of this contestation to the peace agreement. And because of that, we don't have enough strong support from the previous government. And the ICC said, we have we are here to support you and to see the developments. When the new position for Karim Khan, he found that we have to focus their work in some way. We can think that he has an interest to maintain the work of the ICC prosecutor in specific countries with with any development of justice. And when Karim Khan see the kind of advances after the first indictments that we offered for the public, they say that, well, there is a new discussion, and we began new different kind of discussions. He closed the preliminary observation, but we maintain follow-ups in Colombia and even in The Hague. Some of us have been participating in The Hague in new discussion about, for instance, the new policy documents for the ICC, trying to put the experience of the special jurisdiction in order to improve new developments in different kind of experiences for the ICC. And this is the current discussion about the positive complementarity. But also, every year, the ICC prosecutor visits Colombia in order to analyze the implementation of the special jurisdiction in order to see the main concerns from the victims and the main trends for the special jurisdiction. We continue the dialogue, but it is a very open question about the scope and trends of the positive complementarity.
Thanks, Oscar. I actually think if I can add to that, this relationship, it's also, I mean, a very innovative, I mean, the way it will develop, it's very innovative because it's actually at the crux of the peace versus justice debate, and it highlights the complexities of international community intervention in such complex conflict as the one of Colombia, and how we can mediate and find a solution and way forward. So it's possibly one of the few examples of positive complementarity between the ICC, where your process was fully acknowledged as a serious process, and not of dealing with impunity and dealing with the mass atrocities, and not as actually one of the political avenues found to avoid justice. Quite the contrary, actually, it's very well designed. So I think it's one of the few positives, examples of complementarity we can look at in this regard. Hassan's question was due to his following project was actually understanding which elements of the JEP can be actually incorporated in the ICC. So quite the contrary, and that's quite decolonizing in a way, the whole international justice thing. Like, let's see what the Global South can actually teach us, and what are you doing that it's actually improving the international justice mechanisms as well. So it's a little bit the other way around, which I hope we will, is one of the intention of this masters and of the hub that's been constructed here at the Irish Centre for Human Rights in this regard, adding to the complexities that Stefan Parmenter was highlighting before in his wonderful presentation before. Do we have any other questions? Anyone would like to? You can write it in your chat, or you can, they're being shy. Siobhan, go ahead.
Yes. Thank you very much to Stefan and to Oscar for such excellent presentations. I was just interested in your reflections on the role of reparations. Going back to Stefan's comment around the move towards thinking around transformative justice, and then perhaps just learning a little from Colombia, what has been the progress in relation to the role of the special jurisdiction for peace and actually implementing reparations in practice. Thank you. Particularly given the groups and the size of the groups and the particular groups that the JEP has engaged with. Yeah, thank you.
Oscar or Stefan, whoever wants to go first, please go.
Go ahead, Oscar, because I think it's first of all a question about Colombia itself, and I can still jump in on in a general reflection on reparations. That's fine. Thank you.
Yes. Well, I would like to say that Colombia designed a comprehensive model of a comprehensive system of transitional justice using a special jurisdiction for peace for the judicial avenue, a truth commission during 4 years for the discussions related to the truth, and an administrative program for reparations created 10 years, more than 10 years ago. And with a new approach, um, and we have here the discussion about the administrative programs for reparations in Colombia, in Peru, in Guatemala, in Chile, and so on. And the discussion here is the massivity for redress. We are dealing with more than 8 million of victims of forced displacement, more than 100,000 of people disappeared, more than 6,000 of extrajudicial executions, more than 18,000 victims of recruitment of children, and so on. And the main debate behind the administrative program was the financing of the program. Until now, the implementation is have been good advances, but with several difficulties for redress a lot of people in rural areas with collective dimensions of the harm and other examples. And the design of the Colombian model implies that the judicial institution is not in charge of the reparations and put the reparations in the administrative model. But for the victims, this is a problem. This is contested by the victims, and the victims said that no, we need judicial reparations. And we began a discussion with the administrative body, and we are organizing a restorative system to put the alternative and restorative sanctions from the HEP in a specific dialogue with the administrative program of reparations, and to deal with as a unique state, articulating a lot of institutions, the response to the victims and their concerns about the lack of remedies in the Colombian model. But we have a lot of implementation of the administrative model, but with a lot of concerns about the difficulties for a complete implementation of the program.
If you allow me to add a couple of words here, I think Colombia is really facing enormous challenges, and Oscar mentioned the numbers. The sheer numbers are just amazing. This is not to say that other conflicts have far less numbers. Sometimes you have, think of Rwanda, think of Guatemala, think of so many other conflicts. Unfortunately, I would say numbers are often staggering and mind-boggling. So this is definitely a major challenge, how to deal with the large numbers of victims. Another challenge, which was implicit in Oscar's response, I think, is the one of defining the harm. Defining a particular activity as a crime or violation is one thing, but defining the harm that stems from those violations or crimes is another thing. And I think that's often underestimated. In our own research in Bosnia and Serbia, for example, we came to the conclusion that it's not enough to only talk about material harm, land or houses or whatever movable goods, and not only enough to talk about the physical harm that people have incurred themselves, by being jailed or tortured or disappeared. But the emotional harm is incredibly large as well. And this is something that should not be surprising, and yet it's not often talked about. Now, to quantify harm in emotional terms is, of course, very difficult. So how do you then deal with that in order to provide services or types of reparations that can address that harm and those other forms of harm as well? So that's a very, very important element, it seems to me. And finally, I would like to highlight again, if need be, that reparations, of course, is more than just money. Many discourses, even in policy-oriented circles, or in NGOs, or in academia, tend to, well, to think or to reduce that reparations is about compensation only. And compensation is definitely a form of reparation, but it's not the only one. Sometimes it's about rehabilitation, providing services that people can re-enter their lives in society. It's about symbolic reparations as well, like apologies or statues or public spaces. And of course, that idea of guarantees of non-repetition should not be underestimated as well. How to design new systems in order to reduce the risk of similar conflict or similar violence in the future. To say that something is a guarantee, of course, is legal language to try to reduce the risk, because there is no guarantee, as we know from the consecutive cycles of violence that often happen in given societies. But it's a way to draw the attention to the necessity to prevent and to design structures that can help in that direction. So all of these challenges are always there in all kinds of conflicts, and to navigate them next to establishing accountability and truth and so on is a huge, tremendous task in every society. So I have a lot of admiration for the HEP and for the judges who do this difficult work, and the staff members who contribute, of course, and the other bodies that have been set up and are still exercising their influence, like the Truth Commission and others. Thank you.
Thank you, Stefan. I have one question in the chat from Michelle Drury. Could you please, this is for both Oscar and Stefan, could you please speak more about how meaningful transitional justice mechanisms can be implemented where those responsible for implementing such mechanisms, including government officials, were in power when the human rights violations occurred and either perpetrated them or didn't take sufficient measures to prevent the harms, which is one of the most important problems and challenges of transitional justice. The word to you, Stefan or Oscar, whoever wants to take it first.
You want to go, Oscar? Yes, please.
Well, few ideas about this. This is a very complex issue because, for instance, during the peace accords, the negotiators of the peace accords exclude the competence of the special jurisdiction for peace. The special jurisdiction for peace has no competence for former presidents of Colombia. This is an agreement, but and because of that, we don't have any possibility to say anything about previous presidents, former head of states in Colombia. And obviously, they are some reports from the victims presents allegations regarding responsibilities at the higher level of civil authorities. But our competence is focused in the military personnel and the guerrilla members. And the civil authorities only has the opportunity to present voluntarily to the HEP. And the majority of perpetrators that have been special jurisdiction, before the special jurisdiction, have been people previously prosecuted, but not people with any prosecution in the past. It implies that we don't have, we have some limits in our activities, and we have to respect that limits. But I think that um, um, in some way we are doing we are promoting a very a public discussion about higher responsibilities, and the Truth Commission did that with a lot of higher responsibilities in the context of the civil authorities, but without the of individual names. That is another point of the question. As a conclusion, we have, in my view, we have been doing a very important work to break the denial of a lot of phenomena, a lot of criminal patterns, patterns of macrocriminality, crimes against humanity, but only in the context of our. But there is a lot of more of work that it has to be done to construct justice, and this is only the beginning.
Thank you, Oscar. Stefan.
Yes, thank you for the question. If I understand it correctly, it's mostly about the high responsibles, let's say, not only presidents, but also other members of the elites, let's say the ruling elites in the past. But it's true what Oscar says, that former presidents, sometimes certain ministers, have a certain form of immunity. And to break through that form of immunity is not easy, certainly not at a national level. At the international level, it's a bit easier because in principle, there is no immunity at the international level. But that, of course, would imply that you bring these high-level former politicians or military leaders to an international court. And it sometimes works in, for example, former President Milosevic, in the ex-Yugoslavia tribunal, is one example, but of course there are not so many examples, because that in itself is quite a challenge to arrest and to transfer and to then indict and prosecute. That's one aspect. The other aspect, of course, relates to the power position of the former elites. Not in every country, of course, are former elites the ones who lose power all of a sudden. Think of former President Pinochet in Chile, well-known example. Sometimes there is a military defeat, whereby the military and the politicians of the previous regime are basically standing with empty hands. Think of the Argentinian example, which made it so much easier then to prosecute these high-ranking officials. So I think it heavily depends on the power structure at the time, how far one can go with the law. The law is one, the norms, the rules is one, but the way in which the rules are interpreted and are being used differs from the power balance at a certain moment. And that, of course, is also important to keep in mind. And I think it hints at a more general point, that is to say that politics and law are very closely intertwined in the field of transitional justice. They may always be very closely intertwined, that's true, but certainly in this field, because we're talking about these massive violations. And so the same power structure that may have given rise to these violations in the past may still exist in the present and the future. And in such kind of environments, it's much more difficult, of course, to navigate, to operate freely. So again, it's a good example that the HEP is able to do so, and is actually trying to exercise its jurisdiction in the most neutral way. But that's not, of course, always possible and not always easy. But again, it's making progress every time again. After 20 years, we can talk in different ways about calling to account former power holders than used to be the case in the 1990s or the 2000s, let's say. Thank you.
Thanks, Stefan. I'm reading another question in the chat from Maria. Thank you very much for the panelists for this important informative discussion. Question to Judge Oscar Parra. You mentioned how important were face-to-face meetings between the perpetrator, people responsible for the crimes, and the victims in the macro case 03. Were such public hearings used in other micro cases? How impactful were such meetings on the overall, sorry, I lost the track. How impactful were such meetings on the overall work of the JAP? Is it possible at this time to assess the impact of such confrontations on the victims groups affected communities? It's a question about the challenges between the meetings of perpetrators and victims. Oscar.
Thank you, Maria, for this question. And I would like to say that that until now, we don't have these kind of hearings in cases different to cases number 1 of kidnappings by the guerrilla of the FARC and case number 3 of extrajudicial executions. But we have performed encounters between victims and perpetrators in all the macro cases until now, or the majority of the macro cases. It's not easy to assess the impactful of these meetings as a general rule, but we have learnings from the past. For instance, we have learned that it is not possible to promote an encounter between perpetrators and victims if there is not a previous work, in particular with the perpetrator, but also with the victim. Some victims are participating during the hearings. I have during a hearing, for instance, I was leading the hearing, and a victim appears suddenly to the public hearing saying that I am a victim. I found notice about this yesterday, and I would like to participate. And I found this with a lot of emotions and bad emotions about this process and so on. But that is an example of a victim with no previous preparation, previous activities with the victim to prepare her for the public hearing. And we learned that we have to work a lot with the perpetrators, considering the language, the discourse, the justifications, even the kind of spaces that we have to use if we put the victims and perpetrators face to face. But previously, the way that we have to construct the private encounters, we use small groups, focus groups, but sometimes we have a lot of problems with the time or with the massivity of perpetrators and massivity of victims. We learned that we have to take seriously the selection of victims representing other victims during the hearings, for instance, because some people say that I would like to participate, but what we have to do if we have more than 4 victims participating, and we have to select only 20 victims for the hearing. In which way we have to select that victims? What kind of criteria we have to use? And sometimes there are some. It is normal to have in the private encounters some contestation, some confrontation between victims and perpetrators before more public dialogues, more in a more pacific way. And the very beginning, the first encounter between a victim and perpetrator is a very challenging. It's a very challenging moment, and because of that, we have a group of restorative justice, an office inside the special jurisdiction in order to deal with that kind of issues. It's a more interdisciplinary team with psychologists, anthropologists, social workers, and so on, and they are supporting us in this kind of work. And also, we are facing, well, we are analyzing even the vicarious trauma for people like us working with these particular issues. It's not easy to continue working during 8 years. In my case, I did the cross-examination of more than 200 of previous perpetrators, and it's difficult to have 8 hours, 9 hours talking about killings, how you did the killing, why did you do that, what happened in your life, and it is so difficult. And this is another part of the learnings and for the future, and positive practice to analyze for the future, and because of that, there are a lot of issues to take into attention in order to analyze these public hearings for acknowledgement of responsibility.
Thanks a lot, Oscar. I will only take one more question that's been waiting for a little while from Beatrice, and then I'll close because we are a little bit over with time. I'll allow the question to Beatrice because Beatrice has been working for the past 4 years on transitional justice in Colombia, just finished their PhD, moved on a postdoc at Queen's, but still pretty much in contact with people on the ground in Colombia. So please, Beatrice, go ahead.
Hi, and thank you so much, Anita. I think that my question is related to my obsession on my PhD work for both of you, and it is related to how we spoke a lot about law today and how transitional justice influences law, but what about the relationship between judicial and extrajudicial mechanism in this kind of systems? Because this is an important part of it, and I think that sometimes we discussed a little bit about it today, but I think sometimes we take for granted, or we put a lot of expectation of what court can do, but it's not just a court. There are different mechanisms, and truth commissions. In Colombia, there is the Unit for the Search of People Presumed Disappeared that can work together and complement each other. So a little bit of your opinion on that. Thank you so much.
Well, some first ideas to begin about this, because it's a topic. Actually, we have to close this intervention. I have a meeting today with the unit for
Missing persons.
For missing persons, in order to discuss about this. How can we use extrajudicial information from the unit in the context of the proceedings of the special jurisdiction? That is a very big, complex discussion. And as a general rule, we don't have that opportunity. But we have to think in a more comprehensive way, a lot of information that is not necessarily related to individual criminal responsibility, but maybe it's information related to the patterns, for instance. And we have a lot of examples, a lot of debates about the tensions between the truth before the Truth Commission and the truth before the special jurisdiction and the truth before the unit for people disappeared. I think that at this moment, we have to see the empirical work, and we have been waiting your PhD dissertation about your conclusions. But in my view, a lot of people prefer to present some information to the special jurisdiction, and sometimes was had some hesitation to present information to the Truth Commission, considering the incentives of the system, because obviously the HEP has the opportunity to offer juridical security or another benefits, something like that, and the Truth Commission not. And that was a very complex issue, and I would like to see how you deal with that point in your dissertation. On the other hand, considering the unit for people disappeared, the issue there is more an humanitarian work, and I think that there is a lot of information before the special jurisdiction to improve the work of the unit. And because of that, in my view, obviously there are a lot of tensions between the special jurisdiction and the unit. But my general evaluation is that the role of the special jurisdiction strengthen the work of the unit. The judicial work strengthen the extrajudicial work of the unit. And that is, I think that is a positive advance for the comparative approach. Obviously, with a lot of tensions, but we have been using precautionary measures to protect the cemeteries and something like that, to look for the disappeared persons, and with these precautionary measures, we construct a road for the dialogue between the judicial and the extrajudicial in that context. And that is my perspective, but obviously is a contentious issue.
Stefan, if you want to conclude with a few words.
Yes, thank you. I think it's a really interesting question. Well, all of them are, and in fact, it's the best proof that a new program is needed to deal with all these complex and challenging questions. I would like to suggest to also look at it from a historical perspective. That is to say, in the, let's say, early years of transitional justice, as the term was coined in the 1990s, you often see one model as dominant model. It's either a court or a truth commission or something else, and often in a consecutive manner, so one after the other at different moments in time. Very rarely have institutions been designed to work together at the same time in a simultaneous manner. I think Sierra Leone is probably one of the first examples where there is a special court at the time and a truth commission at the same moment, which also creates tensions and ambiguities. Sometimes people, as Oscar was actually saying, are or were not always keen to present information to the Truth Commission because they thought it might have an impact on their credibility or their whatever kind of legal status before a court. So this is one thing, but today what you see more and more, it seems to me, although not exclusively, but more and more, is that idea of complementarity and integral design. Again, Colombia provides an incredible example because that systematic system and that integrated system, as it was called, of transitional justice is quite exceptional. And each body has, from the very start, its own competence and also relationships with other bodies. It's not always like that, but it seems to me that this is most likely going to be further developed into the future, because it becomes clear that courts can do many things, but only so much. And that truth commissions have their own competences and can also produce a lot of collective truth and possibly common understanding, but of course are softer bodies in a certain manner because their recommendations are not court judgments and therefore cannot be enforced so easily. So that idea of complementarity, I think, is gaining ground, and at the same time also complementarity at the same time as a system of design from the very start rather than in an incremental manner later on. But these are just some general reflections. It will have to be seen, of course, how things develop and which kind of organizations are presenting themselves as patronizing organizations who can actually help this forward. It used to be the United Nations or a particular set of countries. Now, with geopolitics changing very rapidly, it remains to be seen which body or set of bodies can still assume those kind of roles to bring together all these stakeholders into one consortium, so to speak. Thank you.
Thank you both, Stefan and Oscar, for responding to all of these questions, which I'm stopping now the Q&A sessions because we went a little bit over time. But we will continue to study and hopefully have more PhDs and more postdocs studying all these important complex issues, which is the intention of only starting the LLM to grow more and more to analyze all these complex issues from here into the future. We have a Transitional Justice Research Cluster just before I close, where actually most of the projects of our PhDs can be looked at with their web pages, but also to see what kind of work they're doing, as well as blogs, as well as news and events are published regularly on the research cluster. And I will add just one thing, because I haven't done much publicity to this, but it's very important. Oscar Parra has also given us one of his papers on the importance of the acknowledgement sessions between the perpetrators and the victims, and he has highlighted some of the challenges and the complexities of preparing the encounters, these encounters, which seem very easy to do, but it's actually one of the most complex things to happen in the field, because we usually, from far, it's very easy to talk about many things, but once you go into the countries and you understand the complexities of the conflicts, where it's actually very dangerous even to talk about it, it's a very different topic. Colombia is still the countries where, despite everything, human rights defenders are constantly killed. And this is important to highlight, because we have we have given an optimistic version of it, but there's also another very black side of it. That's why I think that the judges and everyone operating in transitional justice are doing an extraordinary work in a very challenging context and environment. And we're going to talk about this in the LLM. So please visit our website at the Irish Centre for Human Rights, as well as the research cluster, hoping to expand more and more. For now, I'll close really thanking Siobhan, the Centre, for the support, and most importantly, Stefan and Oscar for having given us lots of your time, which I know is precious, and I know that you're both very busy human beings. So I'm really deeply honored and thankful for your input today and for helping me doing this launch for today. So thanks a lot, and thanks everyone for engaging and with the questions and for being here today. Thank you.
Thank you so much, and good luck with the new initiative. I see you have a first student already in the chat.
Yes.
Thank you very much.
Thank you very much.
Thank you.
To Oscar and Stefan, and congratulations, Anita. And we really look forward to all the work that will come through this master's program. Thank you again. Thank you so much.
Thank you,
very
everyone.
much. Have a nice weekend.
You too.
Bye. Thank you, everyone. Have a nice weekend. Thanks, Siobhan, for your support, as always.